How to do your own small claims court case. So, what I'm going to be talking to you about is when you've got a case that's probably too small for a lawyer to get involved, but you've been wronged in some way and you need justice. And so you've decided, or maybe someone's told you the best option for you is small claims court. In small claims court, and I'm going to be talking about California law, small claims court, you need to start with a demand. And before I get into that, I should mention that I'm an attorney in California and I handle mostly injury cases where people have been hurt or lost a loved one, and that can range from anything from car accidents to falls to elder abuse. And I've helped a number of people with small claims court claims. And in fact, before I started doing what I do now, I used to help doctors who were sued in small claims court and helped defend them. So I have a lot of experience helping people who are bringing small claims as well as defending small claims court cases. The first thing you need to do in California is you need to send a very clear demand letter to whoever it is that you want to sue in small claims court. And you need to keep in mind that this letter is going to be evidence in your small claims court case when you present it to the judge, because it's typically a requirement that you make a attempt to settle the case with the defendant. And I have a sample of the small claims court demand letter on my website, but essentially you want to, address a letter, you want to send it by certified mail or some way that confirms that this person is actually going to get the letter. And then you want to put in there very clearly what it is that you're asking for. You want to say, for example, if it's a car accident, you caused a car accident, you were negligent, you rear-ended me, and as a result, I have this much in medical bills and pain and suffering. And you want to come up with a number. The amount in small claims that you can recover, it changes. I believe it recently was bumped up to $13,000 or $12,000, somewhere around there. So you may, if the case makes sense, just ask for the absolute max that you can ask for, because the worst that can happen is you go to small claims and then the judge will knock you down. If you start too low, then it can be difficult for you to negotiate. And I've seen in a lot of cases where the judges, if you present your case well, they will give you the maximum that you can get or close to it. So you want to put probably in that first paragraph what they did wrong and put in there how much you're asking for. And then the next line you want to say, you want to give them a deadline to when to respond. And typically I recommend giving 30 days to respond. It may seem like a long time, but you want to give them enough time to review your letter and do whatever they need to do to respond. Also, in California, there is some recent law primarily about when you're negotiating with insurance companies and when you're asking for the policy limits that you have to give 30 days. So I think 30 days is a good safe number. Another thing to keep in mind is you don't want to wait too long, because even though it's small claims, it's still governed by a lot of the same laws. And for example, in a personal injury case, you only have 2 years to bring the claim. So you don't want to wait. You don't even want to get close to 2 years. If you think it's going to be a small claims court case, you probably want to do it well before that, as early as you can, because you need to give time for them to receive your letter and to negotiate, and you need time for you to prepare the small claims paperwork. After that first paragraph in the demand, the next section you want to give an explanation maybe about how the accident happened. You can give more details, like on blank date at this intersection you rear-ended me, there was a lot of damage to my car. Very factual, and you want to put in as much facts as you can. Put in information about the extent of damage, like it cost $5,000 to have my car fixed. And then you can put a short summary of what happened afterwards. Maybe the police came, or I had to take an ambulance, had to go to the ER. Although, frankly, if you're taking an ambulance in an ER, then your case probably rises to the level where you need an attorney and maybe shouldn't be a small claims court case, unless you healed really well and that was the end of your treatment. But oftentimes that's not the case. But that's the type of information you want to put. You also want to put a little bit about what, like the diagnosis, or just a little summary of the medical treatment. After that, you want to put again at the bottom of the letter that just reiterate what you put at the top. based on, what I wrote here, I believe that you owe me X amount of dollars, and I am going to pursue a small claims court case if you don't settle this case with me. And again, my demand is $10,000 based on the information I provided and that what I'm attaching. Attached to that letter, you do want to include medical records, photos, all the evidence you have in the case. And remember, this letter could be helpful and evidence in your small claims court case because you're going to present it to the judge saying, hey, I tried to negotiate with them, and here's the letter. And you want the letter to be simple enough for the judge or the commissioner to read quickly. You got to remember that these small claim court judges, they hear a lot of cases, and sometimes they only give you a few minutes to talk about your case. So you want to make it streamlined and clear as possible. What you want to avoid is what I call the adjectives and adverbs and angry emotional language. This devastated my life and it was a severe impact. And you want to avoid as much of that language because it doesn't mean anything to these judges. They see that stuff all day. But if you put in factual information, like instead of this devastated my life, you could put in that the doctor had recommended that I don't work for a week, or instead of saying it was a severe impact, like a bad car accident, say there was $10,000 of damage to my vehicle. Evidence that shows what you're trying to say rather than you just saying it. So you want to put that into a letter. You want to send it by certified mail and make sure you get a receipt so that when they sign it, you have evidence that they received the letter. Sometimes after receiving the letter, they will negotiate with you. That can happen. And then you just have to decide, like, is this worth it for me to pursue, or should I just drop it and not continue the case? If they still won't respond to you, then you're probably going to have to file the small claims court paperwork. So you can go online. LA County has the paperwork and the forms there, and the forms are fairly easy to fill out. And if you need a sample of that, let me know. But you just have to put in information about the defendant and fill out the paperwork. And on the LA court website, there's a self-help section that talks about the different questions you may have. So you can go through that. Once you fill out, you do have to get it filed and served. Filing, it could be something where you file online through the court website, or you may have to go through a court filing provider and also hire someone to serve it. I recommend, you want things to be as perfect as possible for the small claims court case. And there's two things that usually problems that come up. You don't file it correctly, and then you don't serve it correctly. So that's why I recommend maybe paying the money to make sure to go through a court filing person to make sure it gets filed properly. And then for service, you do have to personally serve it. And I recommend hiring somebody to go out and hand the documents to whoever it is, because then you'll get a document back, a proof of service showing that that person was actually served. And later on, when you're dealing with the court and they want proof that the person was served, you have that. And oftentimes you have to file that proof of service anyway into the court. One of the major mistakes I see is that people will just mail the document or not properly serve it. And the defendant will have the opportunity or not show up or just say, I never got the document. And that's going to slow everything down. So you want to prevent that from happening. Once you get to the hearing itself, I recommend that you prepare a packet, and you're going to need a packet for the defendant, for yourself, for the judge. So that way you can just present to the judge all your evidence, and you want to have a letter at the top, and it should be addressed to the court. And it could be basically your demand letter, but you need to say very clearly, because you remember this person's super busy, what the defendant did wrong, why they're at fault, how much money you're asking for, a little summary of the case and the basis for the money that you're asking for. Again, reiterate what you're asking for, and then attach all your evidence. So that's going to be medical records, bills, photos of the accident, or whatever it is. And then you just tell the judge, you could just read your letter at that point to the judge. They'll turn to the defendant and ask them for their story. Oftentimes these defendants are not prepared, and they're going to get a judgment against them. Now, something to keep in mind is before that hearing, what I've seen many times is the court will want you to go outside to speak with the defendant and try to settle it. And at that time, many times I've seen also where the defendants will show up with money and they're willing to settle it. Obviously, be careful with any sort of settlement. Like if they write a check to you, make sure that you're going to actually get paid, because sometimes people will write a phony check just to get out of the small claims process. So that's, another issue that could pop up. Even though you've won the small claims court hearing, another thing to keep in mind is you still have to collect it. So you end up with this piece of paper that's a judgment in your favor. Now you've got to collect it, which can be a whole nother set of issues. And if you decide you don't want to deal with that, there are these collections attorneys that will try to collect on your behalf, but oftentimes they want a really big percentage of whatever it is that you're entitled to collect. So these are issues that come up in the small claims court. I do find that it is an effective tool in order to resolve cases, particularly smaller cases. And it can be helpful, particularly when there's insurance and the insurance company doesn't want to be reasonable or pay. And then the fact that you have the small claims court case, I have seen the insurance companies turn around and start offering money or handle the case differently. And sometimes I've even seen it where they'll send an adjuster to the small claims court hearing and try to get it resolved. If you have any questions about your case, let me know. As I mentioned, I do a lot of more like injury cases, and occasionally, if it's too small for me, I will recommend people to do the small claims court process.